Happy Friday, everybody. I'm Matthew Smith. I'm the host of the Gaveled Down podcast, a part of the Probably Political podcast channel. Essentially, what the show is about is going to be me, a conservative, covering different court cases both from the past and present. And fair warning, I am a conservative, so it will be about the conservative points of view of that case. Different cases have multiple points of view, such as the one we'll be covering today. So, without further ado, let's get into today's case, Marbury versus Madison. So, what is our case today? Well, we are going to be covering Marbury versus Madison, which is best known as the court case which established judicial review as a form of law and jurisprudence in our country. So, first, let's kind of cover what judicial review is. Judicial review is the ability for courts to decide if a law is unconstitutional, typically through appellate jurisdiction, although often it can be done through original jurisdiction as well. So, how did we get to that point? Well, in about 1801, the Jefferson administration was coming into office, and the previous administration, the Adams administration, had gone through what was called the appointment of the Midnight Judges. The Midnight Judges were a group of justices of the peace who were given commissions by the Adams administration, by the Secretary of State Marshall at the time. What had happened is as soon as the Jefferson administration came in, he ordered the new acting Secretary of State, Levi Lincoln, and then later the Secretary of State after him, Madison, to stop delivering these commissions. And Marbury had been promised a commission to be Justice of the Peace of the District of Columbia. Because he didn't receive his commission, he petitioned the Supreme Court to write what is known as a writ of mandamus to compel the executive branch to give him his commission to be a Justice of the Peace. The Marshall Court came up with three main questions to judge this case on. One was whether he deserved this appointment as a matter of law, whether the process that he was going through at the time was correct, and whether the court could actually go through this process and give the writ of mandamus. What they decided to do was they answered yes to the first two questions. So the Marshall Court said, yes, he deserves the commission, and yes, he was technically doing the right process under the Judiciary Act of 1789. However, the third question was whether the court had the right to compel the executive branch to do this. And what the Marshall Court decided is that the Judiciary Act of 1789 was unconstitutional because it gave the court more original jurisdiction under the writs of mandamus than it had originally been given under the Constitution. By deciding that the Judiciary Act of 1789 was unconstitutional, the court gave themselves the power to interpret the Constitution. A lot of people are mistaken on this issue. They believe it came from Article 3 of the Constitution. It did not. It came from this case because it established the principle of judicial review. Judicial review was a new thing. Most countries, even today, still don't have judicial review. They have more of a legislative supremacy. This is why in the United States, the Supreme Court is so important and so controversial to many, depending on the issue. Roe v. Wade would not be as big of a deal to everybody if judicial review was not a principle in American law. This is not to say that judicial review is right or wrong, though. The conservative viewpoint has two main sides. One's the more Hamiltonian side, and one is the more Jeffersonian side. Conservatives don't usually refer to themselves as Jeffersonians or Hamiltonians, but for this case, we're going to be referring to these two as the two archetypes for what would later come to be the many divided sides of conservative thought. This is because these were two of the leaders of the debate between the Federalists and Anti-Federalists, which is a good way to split the ideologies on this case in general. We'll start with the Hamiltonian side. So the Hamiltonians and the conservative schools of thought that come from that side of things are more similar to the Federalist of the time. The Federalists believed that the Constitution needed to be loose enough, but yet strong enough that a federal government could be maintained. And because of that, they believed that the court needed what was known as a voiding power. This would give the Supreme Court, or whatever they wanted to call it at the time within the Federalist Papers, the ability to strike down laws that did not conform to the Constitution and were not an amendment. It's essentially what judicial review is essentially practiced as now. Uh, so they are in support of judicial review. They think that it's necessary to check the executive branch and the legislative branch in any real way. They think that without it, the Supreme Court is overall toothless to defend the Constitution, and there is a lot of merit to this side. The other side, the more Jeffersonian viewpoint, which comes from the anti-federalist or later on Democratic Republican point of view, they believe that judicial review gives the Supreme Court too much power. They argue for a more sort of legislative supremacy, not to say that they don't believe in checks and balances at all, but they believe that the legislative branch should still overall be the most powerful because it is the most representative of the voting body. While this is technically true, they still don't believe that the legislative body should be completely overbearing upon the people. They were still, like all the framers at the time, afraid of a tyranny by the majority, but they were more afraid of a tyranny by an aristocracy rather than that, specifically in the Supreme Court. They saw the Supreme Court and lawyers in general as the new American aristocracy, and were afraid that by allowing the justices to control what they interpreted the Constitution to be, they were enshrining the power of the Constitution upon their heads, to roughly paraphrase Jefferson on the issue. So, which side kind of won out the day? And what's more prevalent in today's society? Well, the Hamiltonian argument is essentially the status quo, and most Americans know that to be the way things are. Because judicial review is a thing, because most Americans are taught very little about Marbury versus Madison, most Americans don't know that this idea first came from the Federalist Papers and wasn't ever in Article 3. They assume that judicial review is just the idea. They don't even call it judicial review usually. They think it's just the idea that the courts interpret the Constitution, and that's just the checks and balances, and that's the way it is. And in a sense, they're right. That is the way it works right now. The Jeffersonian argument is a valid one, and I have been on both sides of that argument. I wrote papers for both sides of the argument. I have sympathies with both sides of the argument. One, I distrust big government, but the other, I distrust the power and tyranny of a majority or of a majority-based body such as Congress to allow voters to or representatives who have to adhere to voters all the power is not a good idea. Just as it's not a good idea to give 9 lawyers who have fancy degrees all the power in the world to decide what the Constitution means. Neither of these is a good idea, and personally, I don't believe that that's exactly what it is. I think both those arguments are two sides of extremes. I think the way it is right now is we have a court that can decide whether a law is technically constitutional, but we also have a legislature that can override them in a couple different ways. One, they can amend the Constitution. That is a thing that we can do. It's very hard, very difficult, but if something was important enough that the courts should not be allowed to stop it, then it should be able to become an amendment, even if that's extremely rare. And because I think it creates more gridlock than it creates a aristocracy that's going to control the Constitution. Because the truth is, there are at the very least two sides, if not a few different points of view within the Supreme Court, and it's very rare that they can come to a consensus enough to make a strong enough decision to truly limit our constitutional rights in that way. So, while there have been some swings and misses, there have been some horrible case decisions that judicial review gave the court the power to do. I think that in general, judicial review is okay to have principle as long as it is used correctly by the court. And that's my take on it. And like I said, conservatives have very different views, especially on this particular case because of its very controversial effects on the law in the country. And I hope that this has taught you a little bit about why judicial review exists, about the different conservative viewpoints on this. If you would like to learn more about the different conservative views on this, more than I can go over in a short video, I suggest you first go read the case itself, go read the decisions yourself, and look up some conservative literature on it. I'm sure there's arguments for both sides out there. And other than that, thank you for watching. This was Gaveled Down, and I'm your host, Matthew Smith. Please like and subscribe, and click the notification bell so that you can keep up with all of the podcasts we have here at ProbablyPolitical. We have a large variety of shows, and I'm sure there's something for everybody out there on here. So thank you. Have a good day. Have a happy Friday. Have a great weekend.